Welcome to the Attorney Talk Podcast, sponsored by Szaferman Lakind with your host, Sam Gaylord, disability litigator in the state of New Jersey. In each episode of the Attorney Talk Podcast, Sam has casual conversations about the law with varied professionals throughout the legal industry. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, Szaferman.com. Now here's the host of Attorney Talk, Sam Gaylord.
Well, welcome to another episode of Attorney Talk, casual conversations about the law. I am your host, Sam Gaylord, and I am a partner at Szaferman Lakind, and I am thrilled today to have with me a partner of mine, Dan Sweetser. Welcome to the show, Dan.
Thank you, Sam. I appreciate you inviting me.
Well, good. I hope that's true. Dan and I have known each other a long, long time, and I'm actually thrilled because I enjoy Dan's, I'll say, sarcastic wit, and certainly hope that that will come forward in our interview today. Before we jump,
you can count on it, Sam.
I know. But before we jump in, to the questions and what I'm going to get through today, but I always ask the guests to tell us something about yourself that most people actually might not know.
So I'm not exactly sure what people know and what they don't know, but if you're talking about above and beyond me being a lawyer and the head of our employment group and a commercial litigator for the last 33 years, what people might not know about me is that I've got 4 sons who are grown up now, but who were all very athletic growing up, and that I had my share of sports and coaching for many, many years while I was trying to practice law and do all that was required with regard to that. And I love sports, and I love coaching them. However, when people tell me that I'm going to miss the coaching and I'm going to miss the games when they don't play anymore, which they're done playing now, I tell them I will not. 17 straight years of coaching travel basketball, and the other coaching that I did was good. I've got my fill.
You got that out of your system?
I think so. Maybe when they have grandchildren, I'll get re-engaged. But for the time being, right now, there's no looking back for me. I'm looking to move on. I'm very, very involved in our athletic organization, which is the Langhorne Athletic Association. I've been on the board for many, many years, both when I was coaching and now even when the kids aren't involved, because they would like to have a lawyer on the on the board. And I'm very happy to help out the community. I think we serve about 2,000 kids, which is pretty incredible. And it's a great organization. So I do that as well. And there's about a gazillion other things I could probably tell you that your audience doesn't know about me, but I'm not exactly sure what it is.
No, that's all right. That's perfect. Now, are any of your sons going to law school or have gone to law school?
I would not allow them to do that.
I am a parent, show them this is not what you want to be doing.
Yeah, so I've got a graduate from Penn State in finance. I've got a senior at Penn State in finance. I've got a graduate of Temple's Business School in finance. And my 4th attempt at a girl is starting in Temple's Business School in finance come the fall.
That sounds wonderful. That sounds like they'll be financially off the parent dole. That's what that sounds like.
Yeah, Sam, you don't miss a trick. I figured you wouldn't miss a trick with the whole finance discussion.
Right, there you go. So, so you just mentioned that you've done, I know you say employment law for 33 years now, and you were started at several other, or you were associated with several other firms. How long have you been with Szaferman Lakind?
Almost 20 years now, which is pretty hard to believe, but I've been practicing since 92, and I was a partner in my first firm. Then a couple of partners and I decided to go out on our own for a few years, and then I was lucky enough to end up at Szaferman.
Terrific. And so just so that everybody sort of understands, employment law or employment litigation, big umbrella, lots of different topics. Anything in particular that you focus on, or just whatever comes down the street?
Well, I mean, no, I wouldn't say I focus on anything. I handle all types of employment cases, and when I say that employment law is one of my main areas of practice, what I mean is contracts. I represent a lot of executives bring in the Princeton area. I'm sure you're well aware of the industry that we have, and a lot of represent a lot of executives in contracts. I do discrimination work both for employees and for employers. Restrictive covenants are always a very hot topic, and for your audience who's not familiar with what I mean by that, many jobs have restrictions that limit their ability to do certain things after they leave employers. And these are restrictions that are enforced by law, and they're very important to understand when you sign a contract, because if you sign a contract that says when you leave that employer, you're not allowed to do certain things, and you're only learning about it after you've left and you're looking for a new job, it becomes a big issue. So, restrictive covenants are a big part of what I do. And then there's a mixed bag of some other things. For example, right now I'm handling a substantial wage payment law claim, which is a claim for a group of employees under what's called our Wage Payment Act, which protects employees to ensure that they get paid the compensation that their employers promise them that they're going to get paid. And there are significant liabilities and exposures to employers who who fail to do that. On the employer side, another case that I'm involved with right now is an issue with the Department of Labor, where they've come in and identified some concerns that they had with my client, and I'm involved in resolving those concerns, which I'm very pleased, and my client's very pleased, are getting resolved. But it's a mixed bag, but there are some focuses that I do.
And you've indicated that you actually do both from the representing the employer and the employee. In your experience, has one sort of been more enjoyable for you as an attorney representing one side or the other?
The answer to the question is yes. More enjoyable. I'll explain to you what I mean. So my initial firm, I pretty much represented only employees. And then when a few of my partners and I left to start our own firm, and we had some business clients, those business clients wanted representation, and that representation was obviously from the employer end. And that was really my first exposure to doing that. And it's enjoyable. I think most people understand, but to the extent it's not clear, doing what we do, litigation, going to trial, is exceedingly difficult and stressful. And when you think about having, an employee's ability to pay their bills and support their family, and make the money that that they're promised they're going to make, it gets very stressful. So, from a global perspective, I do enjoy representing employers these days after doing the primarily employee side for many years, because the stresses and challenges of dealing with individuals who I know have are in difficult situations. They're not there. Employers are generally, it's less personal. At the same point in time, what I don't have that I had before is the satisfaction when I can get an individual the money that they're owed, when I can get them their insurance coverage, when I can get them the money to pay their mortgage, and so on and so forth. I don't now again, I still do some plaintiff's work. I'm selective in what I do.
Yep.
When I say plaintiffs, I mean employee work, obviously. I'm selective in what I do, and I do have some degree of satisfaction there. But from a bigger sense, it's far less stressful representing and dealing with employers. But there is that other side of it, which I enjoy doing, but was taxing. And when you
Sure.
have kids, and you get older, and people start having illnesses and passing away and stuff, getting rid of, I'm not looking to increase the stress in my life. I'm looking to decrease the stress in my life.
Very cool. Well, and I would think too, as someone who also managed their own firm, from an employer point of view, getting if you asked as the attorney, hey, I need this, this, and this, the employer is going to more quickly get you what you need so that you can keep doing what you need to do, versus the individual who, oh, I'll see if I could find it, and sort of has to be a larger follow-up with regards to getting the things that you might need to pursue the claim.
Yeah. So, I mean, listen, you bring up a great point. I really, none of my employer clients, and I represent some big companies these days, none of them have ever expressed any concern that I do some, employee work on the side. And again, I represent a lot of, when you ask me that question, I think what you're referring to primarily is litigation, which is primarily
Correct.
what, and litigation is going to court and getting into these battles and doing what needs to be done to effectively represent a client in a lawsuit. But again, I do a lot of negotiations. I do a lot of advising of employees, particularly executives in our area. But that being said, I've never had an employer client who was concerned or even raised an issue to me about representing employees as well. But if it does come up, if it were to come up, what I would tell them is it's a benefit to you, because I can see what's going on the other side of the table. I've been there. I know what the thinking is, or what it should be, and I know generally, what their strategy will be. The flip side of that is, again, representing employees. I've been there, done that. I'm very familiar with the various employment laws, and there's a lot of them, both state and federal, and I practice in Pennsylvania as well. But I think it's a benefit to my client, whether I represent an employee or whether I represent an employer, that there's a hybrid of whom I represent, because all it does is add to my knowledge and add to my ability to understand the claims and to deal with the claims.
Yep. Do you find, and I know you're licensed in both New Jersey and Pennsylvania, do you find that any particular claims are either easier or more difficult in New Jersey versus Pennsylvania, or vice versa?
Yeah, that's a good question, and I've got a very, very simple answer for you, and that is that New Jersey is by far a far more beneficial state to employees than Pennsylvania. Pennsylvania largely follows federal law. Federal law is generally more conservative than New Jersey state law, and I would say of the 50 states in our country. And for your viewers, they should understand that there's federal laws that apply to many employees, depending on the size of your employer and the issue that we're referring to. But for the most part, at least here in New Jersey, state law is what dictates employee rights, and employers have to follow federal law as well. But the more pro-employee rights in New Jersey, for the most part, are state laws. So if you're an employee, it's much better in the state of New Jersey, given our state laws, which are stronger than federal law. In Pennsylvania, it's much better and advantageous to employers because, again, the law generally in Pennsylvania follows your more conservative federal law.
Gotcha. How about the practice itself, right? Because isn't Pennsylvania almost the individual rules county by county versus New Jersey, which is just New Jersey?
It's a little crazy in Pennsylvania. And again, for your viewers, in New Jersey, even though we're in different counties and each county has a different court, the law and the procedural rules in particular, which is how you do things in that court, are generally uniform. You generally know exactly what's going to happen in each county because it's the same throughout the county. And frankly, I think that's the way that it should be done. Pennsylvania, however, where I live, the Commonwealth, is not that way. Every county has different rules, and there are lawyers who will not go to certain counties because they're not familiar with the rules. I have the pleasure of working with a wonderful paralegal who's been with me for a long time, who greatly assists me in learning the individual rules in the different counties of Pennsylvania where I appear. Now, given that I've been doing this for 33 years, given that I live in Pennsylvania, the counties that I generally practice in, I live in Bucks and I practice in Bucks. Then there's Montgomery, which is adjacent to us, Philadelphia, and Chester County. Those are generally the counties I'm in. And, now after doing this for so long, we don't need to be looking up the rules every time we're there. But to answer your question, it is far more difficult to practice in the state courts of Pennsylvania for that reason, as opposed to New Jersey.
Gotcha. Now, and I know that you graduated law school from Widener, right?
Right.
Okay. And was there anything that sort of prompted you to go to law school? In other words, I'm in college. I think, hey, I want to go to law school, or I don't know what I want to do. So let me go to law school.
Yeah, no, believe me, it wasn't that. I could think of about a billion things to do other than going to law school, if that were it. No, so what happened is I came from a small town up in very top of New Jersey, Vernon, New Jersey, and shout out to Vernon for all you Action Park fans and Playboy Club and the ski area fans.
There you
And
go.
yes, I did work at Action Park for you guys who have seen that video. But there were no significant injuries on my ride, so don't think less of me if you know the Action Park the Netflix special or wherever it is. But in any event, I excelled in math in my small town in in Vernon, and I thought that I had it going on with math. So when I went to Rutgers, I computers were new, and I thought that they were the thing in the future. And again, we're in the '80s now. I thought that they were the way of the future. So I'm like, okay, I'll just major in computer science. That sounds like something that's going to be a thing in the future. And I thought it was a great way for me to pursue my future. What I didn't know is that Rutgers University requires 7 levels of math, or at the time required 7 levels of math beyond calculus. And I did not have calculus in high school. And until I experienced calculus in college, I didn't know much about what calculus was. I nailed it in pre-calculus. Anyway, long story short is I go to calculus, and what I like to tell people is not only did I not know what was going on, I didn't even know what we were trying to figure out was going on. So, after one semester of not doing well, understatement, in calculus, I got called into my advisor's office and said, you know what, maybe computer science isn't for you since there's 7 levels of math beyond calculus. So, of course, I say, are you kidding me? There's 7 levels of math above calculus that I would need to pass in order to get a computer science degree. I agree with you 100%. So listen, I didn't go into a panic mode. However, right at this same time, my sister, who was the first person in my family to become a lawyer, had just gotten her law degree and started at a firm in Trenton, New Jersey. And she was sort of my mentor and who I would bounce things like this off of. And she had suggested that I come work for the firm as a paralegal over the summers instead of working the super go-karts at Action Park. And convinced me to come down for a couple of days a week, which I'm flattered. My sister's a very smart woman and a great lawyer. She said, I didn't want to say anything to you because you were pursuing what you wanted to pursue, but now that that's not there, she said, I think that you were cut out to be a trial lawyer, and I think you'd be a very good lawyer, and this is what you should try to do. And that was 40 years ago.
How about that?
That was about 40 years ago, and I've been trying to prove my sister correct for the last 4 decades.
Very, very cool. Very, very cool. So, and I presume with all of what you handle that you're probably very, very busy every single day. But is there something that in terms of what you do that if you said, oh, this is like what I'd love to do every single day, is there a thing or a type of part of what you do that if you said, if I got 100 new of those, that would be a great day?
Are you talking about in the legal sense or
In the
outside?
legal sense? Yeah, in the legal world.
No, Sam, there's really not any one thing. I've complained to you about this. I mean, I deal with very, very smart people on a daily basis, many of which their job is to make life difficult for me and my client. And I'm a litigator, so there aren't too many what I would say pleasant matters that I deal with. I'm a fighter. That's what my specialty and my role in this firm is, as you know.
Yes.
And I'm flattered by that. And I was particularly flattered by it when I was a younger man. But again, over time, it takes its toll. But no, to answer your question, my litigations are, listen, I deal with some adversaries who are an absolute delight to deal with. They're great. Even though we may have our disagreements, they're a pleasure to deal with. But I also deal with many on the other side, who are very difficult to deal with. And again, they're doing presumably what they think is in their client's best interest. I'm always concerned with how much money it costs to litigate cases, and I treat my clients like they're my family, and I'm very worried about money, probably too much. I've been told I'm worried too much about client money, including by those clients who say,
Mm-hmm.
don't worry about it. We get it. But it's my nature. I hate
Sure.
the legal system. There's a lot of things to complain about that end up costing clients money. And I agree with that statement. But what I don't know, because if I did know, I would try to fix the system, is how to fix the system. I don't know how to make it better.
Right.
It's certain, to say that it's imperfect would be an understatement, but it's very expensive. And these disputes that I get involved with, some of them are silly. They just unfortunately cost my clients a lot of money. So there isn't a particular type of case that I love, more than another.
And in terms of litigation, we talked about it and going into a courtroom and for 25 years prior to March of 2020, every morning I'm putting on a suit. We're going into court, getting ready for what I would determine battle. And now we've had COVID and now the virtual world. And so in your experience, how has that morphed or changed the way in which you go about litigating cases?
It really doesn't. It did for a while. I don't particularly like doing things remotely. I mean, I like, let me just take a step back. One of the benefits of the COVID world and remote practice is with the courts. Before COVID, I can't remember ever having a remote video conference with a court, whether it be for a motion, which for your viewers is going into court to ask for something, or that ask for something not be done in connection with a case, or to update the case and discuss the case with the court on status, so on and so forth. Those things are now somewhat prevalent, and they're great for a bunch of reasons. They can be done much quicker. You save the client a lot of money by not having to drive to court, sit there until you can get heard, and so on and so forth. So they're good. It's a great thing. That's one great result in my view of the COVID world and remote practice. Beyond that, though, I take a lot of depositions, which for your viewers means that I'm asking questions about the case under oath to a witness. Many times it's an adverse witness, somebody on the other side. And I prefer to be face to face with that person in a room when I'm asking them questions, just like I prefer to be face to face in a courtroom asking somebody questions on matters dealing with my cases. So, during COVID, I think I tried 2 or 3 cases on video, which I did not particularly care for, but got it done and they went well. And I did, I don't know, during COVID over a 2-year period, I'm sure it was 50, and I guess 50 depositions, which, we didn't have a choice. So if you don't have a
Right.
choice, there's no use in worrying about it. You got to do what you got to do. However, now I'm often asked if I will do a deposition remotely. And again, my strong preference is to have the witness in the room with me, looking at me, engaging with me. I want to look the person in the eye to get an understanding as to whether or not I think they're being forthright with me, and so on and so forth. I still take some remote depositions, which I don't believe I did, or if I did it on very, very limited occasion pre-COVID. But now, other than these court proceedings that I'm telling you about, I'm pretty much back to business as usual as it was before COVID.
Has it made it easier or more difficult to actually resolve cases?
What?
Do you think the remote depositions, the the discussions with the court, has that made it easier to resolve cases rather than having to go, full throttle to the end for, trial?
I didn't really notice much of an
Yeah.
effect. Obviously with COVID, the courts, had to completely change their way of business, and it's a very complicated system and the process. So, with COVID, cases got delayed. With cases getting delayed, I think there's a less of an interest on both sides of resolving matters, and you're trying to save money and so on and so forth. But again, I'm pretty much back to normal now. So I wouldn't say that there's any effect at all now. But back then, I think other than delays, I don't think that there was, an impact other than delaying cases.
Yeah, and it's interesting because in our world, the advantage, again, you mentioned the driving, and I can now go to court in Camden, Mount Holly, Trenton, all in one morning without ever leaving my desk. So that's beneficial. But in terms of at least what I do, I always found it the best when you could sit there in a judge's chambers, talk about a case, you hammer it right out and it gets resolved. Whereas now online, which we're still virtual, which is crazy, but we're still virtual. And the answer is, it's transactional. So it's like, okay, well, that's fine. And I'll go talk to my people now and we'll come back. Where when you're in the room with the judge, it's like, okay, we're going to get this done. We're going to get it done now. So the delay has been, that's sort of exactly in my world anyways, the thing that I've seen is that whereas things would resolve much quicker, quite frankly, before COVID, now there's these additional built-in delays. I don't know if it's because the insurance attorneys are looking, because they're not driving either, so trying to fill hours in the day for their purposes. But it's just been delay. Not that it doesn't stop moving, not that the ball doesn't continue to roll, but just ongoing delays. So
Yeah. So I mean, so two things on that. Your practice is obviously very different than mine.
oh, sure.
You're going to court. I could definitely see what you're saying. And I would, if I did what you did for a living, that's what I would want to be doing as well. I'd want to be there in court with the other attorney, with the judge, to try to bang the settlements out in your workers' comp cases.
Yep.
But what I do, you have a lot more cases than I do, because the nature
sure.
of your cases is far more condensed than mine.
Mhm.
Mine are more expansive litigations.
Sure.
And every time we go to court, there isn't going to be a discussion about settlement.
Right.
But what I can tell you is, anytime that the court is interested in discussing settlement, they'll ask us if we want to do it remotely or in person. I agree with you 100%. I want people in the room. I want my adversary and his client to be looking at the judge, to getting the judge's input. Or if there's a mediation, for the most part, I like doing mediation in person as well, particularly in bigger cases. There's definitely a significant advantage to being in the room with the decision makers, and whether it be the mediator, arbitrator, or the judge. But in your cases, I could definitely understand that. But in mine, I don't really see that sort of negative effect in getting cases resolved, because my cases don't get resolved, that quickly.
Gotcha. So if people have questions about what you do, or they want to get some information, or they just basically want to connect with you to try and find out more about what you do or how you might be able to help them, what's the best way for people to get a hold of you?
Yeah, my strong preference is email, and my email is dsweetser, SWEETSER, at Szaferman, SZAFERMAN.com. And if you didn't write that down, which I'm sure you didn't, you can always go on our website and you can click on the link to me, and you will get my email address, and you can email me. But and you're welcome to pick up the phone and leave me a message, or from there I'll pick up the phone. But I pride myself on getting back to people very quickly, whether it be via a phone inquiry or an email inquiry. And I don't charge to do that, obviously. And I have many people who call me with different issues at work, and people get upset about all types of things at work. And I understand that. But what I try to do, and I'm willing to do, is, I've been doing this for a long time, and I consider it an obligation of mine as an attorney who's, had a successful career, and I've been fortunate enough to have a nice way of life, that if somebody's got a question that's going to take me 5-10 minutes to answer, rather than spending $500 or $1,000 on a lawyer to answer something in 5 minutes, I'm happy to answer it. If it's something more involved, then obviously we need to talk about that. But I take many calls over the course of the week, and I respond to many emails with people who are upset about work, and I get that they're upset about work. But the fact is that unless you fall into some very specific categories of wrongs that are done to you at work, then there's really nothing that you can do. And I'm happy to walk you through that. I'm happy to give you your options. But I'm also happy to tell somebody, listen, I'm sorry, but this unfortunately is the way it is, and you don't have a claim. And again, you're welcome to check with somebody else. But email and phone is obviously the best way to communicate with me.
Fantastic. Well, listen, I want to say thank you. I appreciate, Dan, that you took the time out and that joined us here on Attorney Talk. It's certainly been a pleasure, informative and sarcastic. I knew it would be in nature. So, again, I appreciate your time and I appreciate you joining us, as I know my audience did as well. So, thank you.
Well, thank you. I enjoyed it, and I appreciate the invitation.
Terrific. So I just want to say thank you to Dan. It's been a pleasure, and everyone for joining us today on Attorney Talk, casual conversations about the law. I look forward to seeing everybody on our next episode. In the meantime, stay well, stay healthy, and we'll talk to you then. Bye now.
You've been tuning into the Attorney Talk podcast, sponsored by Szaferman Lakind, with your host, Sam Gaylord, disability litigator in the state of New Jersey. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, Szaferman.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.